The Madarsa Act of 2004 is not unconstitutional, and the Allahabad High Court erred in its decision regarding the principle of secularism, the Supreme Court declared today. The Uttar Pradesh Board of Madarsa Education Act 2004 was struck down earlier this year by Allahabad High Court as unconstitutional and Ultra Vires. While hearing a challenge to the High Court judgment and granting relief to around 16,000 Madrasas in Uttar Pradesh, the Supreme Court today upheld the validity of the Madarsa Act, which grants administrative rights to Madrasas for their educational functioning. Here is why the Supreme Court made the decision. 1. It regulates the standard of education in Madrasas. And second, it conducts examinations and confers certificates, which allows the student to pursue higher education once they're out of the madrasas and even give competitive exams. That being said, the Supreme Court also noted that both the Madarsa Board and the state government have sufficient regulatory powers to ensure standardized education, even in the religious backdrop of the madrasas. A three-judge bench led by the Chief Justice of India DY Chandrachud noted that while madrasas provide religious teachings, their primary role is that of an educational institution, and therefore the Allahabad High Court erred when it said the act was against secularism. To that effect, the court noted the Madarsa Act is consistent with the positive obligation of the state to ensure that the students studying in it, recognized madrasa, attain a level of competency which will allow them to actively participate in society and even earn a living. But the Allahabad High Court judgment, in the Supreme Court bench's opinion, was not entirely incorrect with regard to the degree process. The madrasas provide Fazil and Kamil degrees and equivalent to the graduate and postgraduate degrees. However, they are only 2 years long in duration. This, according to the Supreme Court, is in opposition to the laws of UGC or University Grants Commission. In non-madrasa institutions, most undergraduate degrees are 3 or 4 years long, while postgraduate is 2 years. This, the Supreme Court said, can be considered unconstitutional. But by and large, the Chief Justice said the act is to protect the right of minorities in Uttar Pradesh, and madrasas do ensure that students get practical learnings. On the topic of secularism, a key point raised in the Allahabad High Court's March 22nd judgment, the top court noted, according to Article 21 and the right to education, the freedom of choice of religious and linguistic minorities must also be considered. Therefore, a child can enroll in a madrasa for education. Further, the Supreme Court said some things can be improved under the Madarsa Act. The board, with the approval of the state government, can enact regulations to ensure that the religious minority educations impart secular education as well and are of the standard without destroying the minority character.